We're still reading the divorce case of Vincent Guthrie and Dorretta Guthrie. We're now at the stage where the judge is making the orders. Now, having read through the case, you should have an idea what the order will be like, because remember, the judge had already stated that Mr. Guthrie does not seem to have been successful in disturbing the 50-50 rule in his claim that one of the properties is 100% his and the other is 60 his and 40 Mrs. Guthrie. And we also see Mr. Guthrie's desire to have Mrs. Guthrie repay him for withdrawal she made from their joint accounts. But we have seen that the judge has stated that he has not demonstrated that such withdrawal were unjustified or were in breach of any agreement, any formal agreement regarding the account. So we continue. In light of the findings which I have made above, I make the following orders. 1. The claimant, Mr. Guthrie, and the defendant, Mrs. Guthrie, are each entitled to a 50% interest in the property at Hopewell and registered at volume 1313, folio 776 of the Register Book of Titles. 2. The claimant and the defendant are each entitled to a 50% interest in the properties at Sheffield and registered at volume 1214, folio 792 and 793 of the Register Book of Titles. 3. The claimant and defendant are each entitled to a 50% interest in the property at Pitkelly and registered at volume 134, folio 933 of the Register Book of Titles. 4. The claimant and the defendant are each entitled to a 50% interest in the property located at Lot 93, Non-Parallel Land Settlement, Negril, in the parish of Westmoreland. 5. All the properties are to be valued by a valuator agreed by the parties, and if no such agreement is arrived at within 30 days of the date of this order, the Registrar of the Supreme Court shall appoint such a valuator, provided that the parties may, by agreement in writing, entered into within the time set for appointment of a valuator, use valuations of the proportions previously obtained and jointly paid for by them upon the properties being valued, and the valuation reports provided to the attorneys at law for each party. Each party shall have the option to purchase the interests of the other party, provided, however, that the claimant, Mr. Guthrie, shall have the first option in respect of properties at orders 1 and 2, and the defendant shall have the first option, that's to purchase the other's interest, in respect of properties at orders 3 and 4. Such options are to be exercised within 120 days of the delivery of the valuations to the parties' attorneys as aforesaid. 7. In the event of the failure of any party to exercise his or her option within the time limited by Order 6 above, the other party shall have the right to purchase the interest of the person so failing. 8. In the event that the defendant exercises her option to purchase the property at order 3 above, she will pay the claimant $1 million in reimbursement of the sums borrowed for the construction of the home. Such sum is to be added to the cost of the 50% of the valuation for which she would otherwise be liable. 9. Where neither party is able to purchase the property as set out herein, such property may be sold at public auction or by private treaty, and the proceeds divided in the same proportions as the ownership interests declared. 10. The registrar is authorized to sign any document to give effect to the orders made herein. 11. The defendant, that's Mrs. Guthrie, is not indebted to the claimant in respect of any sums withdrawn from any of their jointly held accounts. 12. The claimant's claim for payment of any other debts other than any debt within these orders is denied. 13. 2/3 of the defendant's costs, that's Mrs. Guthrie's costs, are to be paid by the claimant, Mr. Guthrie. Such costs to be taxed if not agreed. 14. Liberty to apply. That's Roy K. Anderson, puisne judge, July 19, 2011.